Hello and good morning friends, welcome to CEC Live Lectures. Dear friends, today in this session we would be continuing further with our series on copyrights, and today we would be talking on rights under copyright law. And for this discussion we have once again with us in our studios Mr. Ashwani Sewal. Mr. Ashwani Sewal is Assistant Professor in Faculty of Law, University of Delhi. Mr. Sewal is a young, energetic and dynamic professor who believes in giving utmost of his knowledge and sharing utmost of his experience with the students. Therefore, through this live platform, he exchanges information with you all. Friends, if you want to ask questions from Mr. Sewal, then you can call right in the CEC studio. You can contact us through our toll-free number. Our number is 1800110430. I repeat, our number is 1800110430. You are requested to call in the last 10 minutes of the lecture so that first you understand today's topic, and afterwards, yes, we promise to give answers to your questions in the last 10 minutes. So let's welcome our guest, Mr. Ashwani Sewal, and let's try to have insight into today's topic. Hello sir, welcome to the lecture.
Hello Geetika. Good morning viewers. Well, I hope all my viewers remember what we discussed in the previous session, because first I will complete the discussion that I was continuing in my previous session. Then I'll jump to the next area, that is called rights under the Copyright Act. Well friends, if I recapitulate a very important point from my previous discussion, which we are going to conclude today. In the previous discussion, I was talking about the important case law which heralded a new principle for determination of originality in the copyright, that is called Modicum of Creativity. Viewers, if you recall, there was a case highlighted by me in my previous discussion called Feast Publication versus Rural Telephone Service Company. It is a United States Supreme Court case of year 1991, where in United States a new principle was propounded, replacing the earlier wrong principle called sweat of the brow, and the new principle is called Modicum of Creativity. Well friends, what I recall from my previous discussion, I was talking about the Indian case law which has replicated the principle propounded in Feast Publication versus Rural Telephone Service Company to India in year 2002, that is DB Modak versus Eastern Book Company. A case law that I was discussing, I recall that I was mentioning about the facts of that case, and after the facts of that case, I was talking about the court's approach of opting a new principle on the basis of Feast Publication versus Rural Telephone Company in India, in Eastern Book Company versus DB Modak. Well friends, this new principle is called Modicum of Creativity, and the case in the Indian context which speaks and which reiterates about the principle of Modicum of Creativity is DB Modak versus Eastern Book Company. In this case, my friends, you must be recalling the facts wherein I told you that DB Modak, the respondent in the case, brought a similar venture of Eastern Book Company. Eastern Book Company does have its venture called Supreme Court cases, wherein it provides Supreme Court cases with certain case comments and all to the subscribers of Eastern Book Company or to the subscribers of SCC, their online subscription or online legal subscription database. On the other hand, the respondent in that case, my dear friends, DB Modak, started his own venture called Grand Jurix, wherein they also started their business of a similar nature of providing the Supreme Court judgments to the practicing lawyers or to the subscribers of the Grand Jurix, which is also an online source, or which was also an online source for providing the Supreme Court cases to the subscribers. Well, the bone of contention in that matter, my dear friends, was in relation to the reproduction of the work done by DB Modak, the respondent, without the prior authorization from Eastern Book Company. The allegation of the plaintiffs in that case was in relation to reproduction done by DB Modak without the prior authorization from Eastern Book Company. In their defense, the defendants in that case, my dear friends, stated that since the work that they have created or they are involved in creating are Supreme Court judgments, and the reproduction of the Supreme Court judgments, or for that matter judgments of any court in India, or orders of the tribunals or orders of the authorities in India by purview of section 52 are public works, and nobody or no entity can have a copyright on a work of in the form of the judgment, in the form of the authorities, in the form of public orders. So whatever the defendant in that case, DB Modak, was doing under the purview of 52 as per their defense. But my dear friends, in that case, the Eastern Book Company alleged that they are not alleging against the reproduction of the judgments to be done by DB Modak, the defendants. Their main allegation basically lies or revolves on the point of verbatim copying of their work done by DB Modak, the defendants in that case. Well, my dear friends, as far as judgments of the courts are concerned, they can be anytime reproduced by anyone. No restriction or no prohibition is there, no limitation is there as far as the reproduction of judgments are concerned. But in this particular case, my dear friends, the defendants were not only reproducing the judgments, they were rather reproducing the entire style of the plaintiffs as alleged by the plaintiffs. They were rather verbatimly copying the entire style of representing the case in their venture called Supreme Court cases. That was basically alleged by the plaintiffs in that case, that the defendants are into the act of imitating the entire style of their representation. So we all understand, and all my viewers I hope understand, that expressions are copyrightable, ideas are not. Well, Supreme Court cases is basically a repository where cases of Supreme Court can be accessed by the seekers or by the people practicing in courts or by whosoever, and the style of the representation of Supreme Court cases of Eastern Book Company is quite unique, wherein they just don't reproduce the entire case as propounded by the Supreme Court or for that matter by any other court. They rather apply their ingenuity and creativity in making that representation more reader friendly and very comfortable for the viewer and the reader. They rather do make some additions, some comments are added, some additional citations are provided of similar cases discussed or decided by other high courts in the country or by the Supreme Court itself on previous occasions. So there are certain additional efforts which lies in the Supreme Court cases as a venture. So it is not simply the mere reproduction of the judgments of the Supreme Court. Eastern Book Company through SCC provide additional things. So the plaintiffs in that case were basically emphasizing on their work that was additional work done by them in procuring those judgments to the people in the form of comments, in the form of citations, in the form of extracting the ratio from the judgment, in the form of dissecting the obiter from the judgment, etc. So they were claiming their right on those additional portions, not as such on the judgment, because judgments are not copyrightable. Their allegation was very specific against the defendants. The defendants in this case have imitated, substantially copied the style of Supreme Court cases in their venture called grand juries, and the court was rightfully decided the case in favor of Eastern Book Company, and DB Modak was injuncted to further go ahead with their business of reproducing the work in such an imitative manner, or you can say reproducing the work by verbatimly copying it. Had they done it in a different format or by making their own creativity or by incorporating their own creativity, they would not have been restricted by the court. But since they had not applied their creativity, rather they just imitated the style of the Supreme Court cases, which is a venture of Eastern Book Company. So that's why they came to the trouble, or they were into the trouble, and the court decided against them, my dear friends. With this case in India, there came a new principle called Modicum of Creativity on the linings of Fiest Publications versus Rural Telephone Service Company case of United States, wherein we understand that there has to be some minimal amount of creativity in the work. If the creativity does not lie in the work shall not be conferred the copyright protection in the absence of the modicum of creativity, in the absence of minimal amount of creativity in it. Well, my dear friends, at this juncture I would like to make you understand that it is also very important for you to discern the distinction between the requirement of originality in the case of copyright and the requirement of novelty in the case of the patent law. Well, friends, originality requirement, as the term modicum of creativity or minimal amount of creativity suggests, is a requirement which poses or which requires the applicant to prove minimal amount of creativity. The threshold of creativity need not to be very high. On the other hand, in the case of the patent law, where the requirement of novelty is there for obtaining the patent protection on the invention, which is a requirement of very high threshold, and it is completely unlike to the requirement of originality in the case of the copyright. The broad distinction, or you can say the specific distinction between these two separate requirements of separate intellectual properties can be understood in very simple manner, that in the case of the copyright, the requirement of getting the copyright registered, or you see conferring the copyright on the person, is the requirement of originality in the work, which remains always at a very low threshold, vis-a-vis to the requirement of novelty, which is a very high threshold requirement to be proved by the inventor claiming or seeking the patent protection under the Patents Act. Well, my dear friends, now let us start the new area or new topic under copyright law, which is of utmost importance for all of us to understand. What are the different rights provided under the copyright law? We all have understood so far that copyright basically is conferred on the expressions, not on the ideas, and we have understood that copyright can be conferred on a stipulated subject matter of section 13 of the Copyright Act. I have discussed elaborately different kinds of subject matters as discussed under section 13 of the Copyright Act. To recapitulate, literary works, artistic works, dramatic works, cinefilms, musical works, or you can say sound recordings, are all can be conferred a protection of copyright under the Copyright Act, because all these works are subject matters, stipulated subject matters or enumerated subject matters under the copyright law of copyright protection. The next thing that we should know as to what are the rights that will get conferred on a person when a copyright is conferred on a person, or when he or she creates a copyrightable subject matter. Since it is a automatic protection regime, so there is no requirement of formal registration to be done mandatorily by the applicant. The moment the applicant creates the work, immediately the copyright gets conferred on the person. But what are the different rights that he can exercise stipulated under the copyright law, that we must understand? What are the different privileges in the form of the rights which he or she can exploit after creating the work, that we must understand? Well, my dear friends, it is said that copyright confers bundle of rights on a person. The term bundle of rights is used in a very popular sense as far as the copyright law is concerned, and it is said and understood that copyright comes with bundle of rights. How and on what basis it is said that copyright comes with bundle of rights, and what are those bundle of rights? We must understand that. Let us jump straight away to the section, that is section 14 of the Copyright Act, which provides the meaning of the copyright, or you can say which provides us different rights which will get conferred on a person after obtaining the copyright protection. You may apply it practically because see, whatever work you are creating today, if it is a subject matter of the copyright and if it is original work, original expression of yours, then these are the rights which you can exercise immediately after conferment of the copyright, and copyright gets conferred the moment you create the work without any formal registration procedure to be followed by you. Let us see the different rights provided under the copyright law. Well, my dear friends, if you look at the slide on your screen, this is the language of section 14 reproduced here, which reads that for the purposes of this act, copyright means the exclusive right, subject to the provisions of this act, to do or authorize the doing of any of the following acts in respect of a work or any substantial part thereof. Well, my dear friends, the main language of section 14 says that section 14 provides to the owner of the copyright the different rights enumerated under section 14, and the owner of the copyright shall be empowered to exclusively exercise those rights or to authorize somebody to exclusively authorize those rights at his behest. Or you see, it is also clear that the owner of the copyright have the prerogative of using the work of his creativity exclusively. The whole work he can use, or a substantial part also lies to him. So anybody who imitates the substantial part of his work will tantamount to infringement, or the act of the person imitating the substantial part of the work will tantamount to act of infringement. So the point is, it is the exclusive right of the owner to either do the following things mentioned here on his own exclusively, or authorize somebody to do those things at his behest by assigning or by licensing it or by transferring the work to be done by the assignee or the licensee respectively. What are the rights provided here? Let us have a look at those rights. Before telling you the different rights which will come here or which will appear here in this language of section 14, let me tell you that there are different categories of works which we have seen under section 13 on which a copyright can be conferred. So, well, my dear friends, with different categories of works, different rights are available, or there may be a variation of rights available with the nature of the work on which you are seeking a copyright. It is a beauty of the copyright law wherein there is no uniformity as far as the rights to be conferred on a person's work are concerned, because with work or with the kind of work or category of work, the rights which will accrue to that work will differ, as highlighted under section 14 and explicitly written under very first clause of section 14, which reads that in the case of literary, dramatic or musical work not being a computer program, the following rights are available to the owner of the copyright. These are: right to reproduce the work in any material form, including the storing of it in any medium by electronic means; then the right to issue copies of the work to the public, not being copies already in circulation. The third right on your screen is the right to perform the work in public or communicate it to the public. The fourth right on your screen is to make any cinefilm or sound recording in respect of the work, and to make any translation of the work, then to make any adaptation of the work, to do in relation to a translation or adaptation of the work any of the acts specified in relation to the work in subclauses 1 to 6. Well, friends, if you look at this slide, there are different rights available in the context of literary, dramatic or musical works created by the creators of those work, and the yellow highlighted portion here provides you the idea as to what are the different rights which are available to the person on the following kinds of works, on the literary, dramatic or musical works. These are written in the yellow portion, or if you can easily understand, these are highlighted in the main language in front of the screen or on your screen in front of you, to reproduce the work is the foremost right which emanates under section 14. Reproduction of the literary work, dramatic work or musical work done by the person in an immaterial form, including the storing of it in any medium by electronic means. Well, my dear friends, reproduction is the first and the foremost right provided here. What does reproduction mean? Reproduction here means copying that work or making copies of that work. As far as this right is concerned, this lies exclusively with the owner of the copyright in the context of literary, dramatic or musical works. And reproduction of the work is not allowed without the prior authorization of the owner of the copyright. And anybody who ventures to reproduce the work in any material form, including the storing of it in any medium by electronic means, even storing of the work in any medium by electronic means, tantamounts to reproduction of the work. If I exemplify it, my dear friends, if you store something in your personal computer or in any of your gadgets without the authorization of the owner, if you store a copyrighted material in your device, it tantamounts to reproduction, because storing in any medium by electronic means also has been made or does fall within the definition of reproduction of the work in any material form. So reproducing the work without the authorization, reproducing which work? Literary, dramatic or musical work without the authorization will tantamount to infringement under section 51, and it is the prerogative or the exclusive right provided to the owner of the copyright to reproduce the work. No other person can do that without his prior authorization. The next right on literary, dramatic or musical works, my dear friends, as provided under 14A2, is to issue copies of the work to the public. Is to issue copies of the work to public. This is the right which is appearing on your screen. It is the right to issue copies of the work to the public, not being copies already in circulation. Well, my dear friends, the language is little ticklish to understand, but let me make it very simple for you. Issuing copies of your work is your right. If you are a originator of a work, if you are a creator of a original work which is a copyrightable subject matter or which falls into the definitions of literary, dramatic or musical works, then it is your exclusive right to issue the copies of that work to the public. Nobody else without your prior permission can issue the copies of that work to the public. But my dear friends, this right is limited right, because the later limb of this section or later part of this sentence puts the limitation, and it reads that the issuance right of the work to the public is a right to the owner of the copyright only till the stage when the copy has not come to the circulation. Once the copy comes into the circulation, the right of issuance of that work to the public gets exhausted, or with the first issuance of the work to the public, the right of the owner to have a further control on the issuance of the work to the public goes away, or it diminishes, or it ceases. So if I would like to exemplify it to make you understand, suppose you have got one copyrighted work which you own because you have created that work and it is a proper subject matter to be conferred a copyright protection. Immediately with the creation of that work, you have been, by purview of section 14, conferred with a right called right to issue copies of that work to the public. The moment you issue that work to the public once, the right no more lies with you, because it is a one-time right. If you look at the language, it reads that issuing copies of the work to the public, not being copies already in circulation. So the copy once come to the circulation, this right of issuance of copies of the work to the public diminishes, ceases, or it does not anymore lie with the owner of the copyright, and he cannot exercise this right any further. The best example to understand this kind of a right or the exercise of this kind of a right is in the case of textbooks or any kind of books, my dear friends. Suppose you have purchased a book and now you want to resell it to a second-hand seeker, or suppose you want to lend a book to your friend. Nobody can control you to distribute it, to resell it, to lend it to your friend, because issuance of the work to the public is a one-time right of the owner of the copyright, and the copyright owner who had written that book, either he is the copyright owner if he has kept the copyright with him, or the publisher who has taken the copyright from the author of the work, he is having the copyright. That owner can never exercise the control on the further issuance or distribution of the work. So any buyer, legitimate buyer of the book, can further resell or distribute it, disseminate or issue it to anybody, because the copy has already come to the circulation. But if it is a case where copy has not come to the circulation, it lies with the printer, or in the process of printing, the work has not come to the public domain or into the circulation, in that case, my dear friends, the issuance right still lies with the owner of the copyright, and he can exercise it only once. Or you can understand it by referring to a first sale doctrine, which reads that with the first sale of your work, the right of the issuance of the work to the public goes away. It is also said, or it is possible to understand the principle of first sale by referring to the concept of exhaustion. Concept of exhaustion, my dear friends. Under the copyright law or under intellectual property law, once you have exhausted your right under copyright law specifically, in this case, it is an explicit limitation that once you have exhausted your right after issuance of the copies of the work to the public, or after making them available to the public in circulation, you cannot have further control on that. And that is quite interesting, because see, I don't find any other right limited in this manner under section 14 of the Copyright Act except this right of issuance. So I was little curious to know the rationale, the logic behind this limitation put here in this last limb. The rationale, that the possible rationale that seems to me is that the copyright law, apart from conferring a right of copyright to the creator of the work, takes into the consideration the importance of works dissemination, importance of distribution of the work, because the underlying philosophy on which copyright law revolves or is based on, it says that copyright law basically promotes the science, art and culture, and it is meant to promote the science, art and culture. So if somebody is given a control on the issuance, then that person will issue the copies or distribute or disseminate the work at his or her whim and fancy, and he may be whimsical at times to curtail the dissemination, distribution and issuance of the work, which is going completely in conflict with the idea of copyright, which reads promotion of art, literature or culture. So the limitation put here is in consonance with this philosophy of promoting science, promoting culture, or distribution of the work or dissemination of the work. Well, my dear friends, I rest here and then we'll continue with the further discussion on few more rights under section 14 provided to the owner of the copyright. Thank you. after understanding these two important rights, friends, the right to reproduce the work in any material form, which includes storing of the work in any medium, even by electronic means. The next right that we understood was issuance of the work to the public, not copies already in circulation, which I have elaborated little bit to all my viewers. Well, the best case law, my dear friends, to understand the right of issuance of the copies to the public, or which is also understood by referring to the doctrine of first sale or by the concept of exhaustion, is a case called John Wiley versus Prabhat Chandra. And there is another case of John Wiley itself. Both the cases were fought in Delhi High Court. One case, the first case, that is John Wiley versus Prabhat Chandra, was decided by Justice Manmohan Singh, and the another case was ex parte decided by Justice Ravindra Bhatt, which is also involving John Wiley and publishers. Well, my dear friends, I'll take up the issue of first sale doctrine and exhaustion separately in future, and I'll be elaborately or exhaustively covering the John Wiley versus Prabhat Chandra, which is a case on issuance of the work to the public, in the future whenever I will be discussing it. But first let us complete different rights which are provided under section 14. The third right that comes is the right to perform the work to the public or communication of the work to the public. Well, my dear friends, as far as this right is concerned, it provides an exclusive right to the owner of the copyright to perform the work to the public. In the context of literary, dramatic or musical works, these are the rights which are available to the public, to the owner of the copyright, to perform the work to the public or to communicate it to the public. If I explain it, my dear friends, suppose you have created a work which is copyrightable work, either a literary, dramatic or a musical work. It is only you who can perform that work to the public exclusively, or it is your prerogative to authorize somebody to perform that work to the public. So anybody found performing your work without your without your prior permission can be made liable for the offence of infringement under the copyright law and can be held accountable for the infringement of copyright law, because performance is your prerogative of your work to the public. Well, my dear friends, the noticeable part or the thing that needs to be elaborated or needs to be elucidated here is that performance right has been given to the owner exclusively, but this right will not get infringed if somebody without your permission is performing in private, because the word public is used here, which demonstrates and signifies that performance to the public is the right of the owner. So if somebody is found performing in private, say at home, the father is performing on a song in front of the kids, or if kids are performing in family function in a private sphere, then that will not be amounting to infringement of the copyright, because the right of the owner is the right to perform the work to the public. So anybody who will be performing in public will be infringing the copyright of the owner, and if somebody is performing on the copyrighted material of the owner without the permission of the owner in private, that is allowed, because the public word is used, not the word private. Then another right which appears here is the right to communicate the work to the public. Well, my dear friends, communication means making the work available to the public. It is the prerogative of the owner of the copyright to make the work available to the public or communicate it to the public. Well, my dear friends, it is the prerogative of the owner of the copyright to communicate the work to the public. If somebody else is found communicating or involved in the act of communicating that work to the public, that would tantamount to infringement. Well, if I explain it little bit, well, my dear friends, I have one very important real-time case law in my mind which explains it beautifully. Suppose you have allowed your virtual space, being the internet service provider, being the ISP, which can also be called intermediary, you have allowed the virtual space for the communication of some copyrighted material to certain people who are not the legitimate owners of that copyrighted material. So if you have allowed that virtual space for communication of the work to the public, those who are communicating by uploading the content through your medium, they would of course be made liable because they are communicating the work to the public without the authorization of the owner of the copyright. It is the owner who can communicate exclusively, no other person can do that. Since in this instance where intermediary is allowing the virtual space to certain subscribers for communication of the copyrighted material of some third person who is not at all in the picture and he has not been first approached for taking the permission. Without his permission, the subscribers of that virtual space are communicating the work to the public. Say they are uploading some musical works, songs, etc. or cinefilms, etc. on virtual medium, and which is being facilitated by the internet service provider, by the intermediary here, then in that case, my dear friends, the act of the subscribers of uploading that content will tantamount to copyright infringement, because communication is the exclusive right of the owner, or it can be done only at the behest of the owner of the copyright. Apart from that, my dear friends, in this instance, since the intermediary, the internet service provider, is also facilitating those subscribers, their responsibility can also be fixed subject to section 79 of the Information Technology Act, which is not the discussion of the matter, but still I would like to throw some light on this aspect because it is very crucial nowadays, where we see a lot of platforms in the internet medium, in the cyberspace, where songs or cinefilms, etc. or copyrighted stuff of certain people are provided without the authorization from the owners or real owners of that copyrighted content. In that case, even the internet service provider who just facilitates the upload of that content can also be made liable if they had some role in the initiation of the transmission, if they had some role in the selection or modification of the content, if they had some knowledge that this content is being uploaded in, it is a copyrighted content of somebody else, then also they will be made liable. Or if on the notice by somebody they have not swiftly removed that content, or if they fail to swiftly remove that content, the internet service providers can be made liable by purview of section 79. Otherwise, by purview of the main language of section 79, they remain immune from any kind of a liability, because their work is only to facilitate, and they act only as a conduit to transmit the material, and it is also necessary for the freedom of speech and expression that they facilitate the dissemination of the work in this manner. So communication, the work to the public, and performance of the work to the public are the two important rights provided to the owners of the copyright, apart from two earlier rights which we have discussed, which are reproduction and issuing copies to the public, not copies already in circulation. Now we have come to the next right, which is to make any cinefilm or sound recording in respect of the work. Well, my dear friends, the section 14 of the Copyright Act says that in the context of literary, dramatic or musical work, it is the exclusive right of the owner of the copyright to do or authorize the doing of any of these things, which includes even making a cinefilm or sound recording in respect of that literary, dramatic or musical work. So if you are a creator of a literary work, or of a dramatic work, or of a musical work, since you are the creator of that work, it is your prerogative, my dear friends, to make a cinefilm or sound recording of that work. Nobody else can make a cinefilm or a sound recording of that work without your prior authorization. The best example to understand this work or this right, my dear friends, is from the movies of the Bollywood, where they take the permission from the owners of the literary work, dramatic work, etc. before making cine films on those literary works or dramatic works. The latest example from the Bollywood is the movies of movies based on the novels of Chetan Bhagat, where you see the producers of the film had taken prior permission from the owner Chetan Bhagat in respect of making cine films on the basis of that literary work of Chetan Bhagat. Two States was one movie which was based on the novel of Chetan Bhagat. There was another movie, Half Girlfriend, which was again based on the literary work of Chetan Bhagat. So it is his prerogative to make a cine film on that work, but he can also authorize somebody, if approached, to allow that person to make a cine work or a sound recording in respect of that work. The next right, my dear friends, that comes here for our consideration and for our perusal is the right which is called the right of translation of any work. So making a translation of the work is also the prerogative of the owner of the work. Suppose you are a creator of one literary work or a dramatic or a musical work, my dear friends, and if you want to translate your work, you can do that. But if somebody else is translating your work and claiming the ownership on that work, that is not allowed, because making translation in any of the languages is your prerogative and exclusive right. It is only you who can authorize somebody else to do the translation. Similarly, there is another right called making any adaptation of the work. Even the adaptation right is provided to the owner of the copyright. Nobody else can go for the adaptation of the work, or you can, in a simplistic manner, can understand, nobody can go to change the format of your work without your prior permission or authorization. The meaning of adaptation is provided under section 2A of the Copyright Act under definitional clause, and we will construe the meaning of adaptation in the similar manner as provided under 2A, my dear friends. Adaptation there means conversion of the literary work into a dramatic work, conversion of a dramatic work into a non-dramatic work, etc. The complete elaboration lies under 2A, which you can refer to understand what does adaptation mean. But at this juncture, I believe conversion of one particular format into another format is also the prerogative or exclusive right of the owner of the copyright. Nobody else can convert your literary work into a dramatic work without your permission. It is your prerogative. Nobody else can change your dramatic work into a non-dramatic work without your permission. It is because it is your prerogative by purview of this right provided here. So we have seen that right to reproduce the work, right to issue copies to the public, not copies already in the circulation, right to perform the work into the public and communicate the work to the public, right of making a cine film or a sound recording in respect of that work, right of translation and adaptation are the rights exclusively provided to the owners of the copyright by purview of section 14. The last clause here is very significant because it says that in the context of translated work or in the context of work which have been created by you after adaptation, all the rights provided under clause 1 to 6 are available even with the translated version or with the version which has come into the existence after adaptation of the work. Which means, suppose I have created a work which is in Hindi language. Tomorrow I have converted into English language. So my right on this work in Hindi language as provided under 14 are many. I can reproduce that work. It is my prerogative to make translation of that work. It is my prerogative to perform or communicate that work, and so on and so forth under 14. All these rights which are available to the first version or to the first creation of mine, all these rights will be applicable or will accrue to my work of translation as well, to even English version of my work. So it's kind of proliferation of the rights on the translated work. Once I have converted my work into Telugu, into Malayalam, into Hindi, into English, into Urdu or any language, all rights which are stated here under clause 1 to 6, reproduction, further translation, communication, further adaptation, will also be available with those translated and with those works converted after adaptation. It means that there are bundle of rights available under section 14 to the owners of the copyright, and there are bundle of economic rights available under section 14 to the owners of the copyright. That is why it is popularly called that copyright confers or comes with bundle of rights. In nutshell, reproduction is the main right, issuance limited in extent, only one time right in the form of issuance or distribution. Communication or performance is a right which remains forever till the cessation of the term. Translation and adaptation are another two rights which are important rights which will remain with the owner of the copyright till the cessation of the term or till the enjoyment of the copyright. Well, these rights gets proliferated by purview of clause 7 of section 14 clause A, and that is why it is called bundle of rights. Well, my dear friends, I intentionally skipped to highlight on very important aspect. If you look at the screen, in the language of section 14, in the very beginning it is written that in the case of a literary, dramatic or musical work not being a computer program, so they are excluding the computer programs. Deliberately, the language here has made it clear that the legislature wanted to confer rights on computer programs separately, and the legislature wanted to provide a separate clause for the conferment of rights in the cases of computer program. Since I have already discussed, and since it is very clear from my previous discussions that literary work includes in the definition computer programs, and computer programs in the copyright law are called literary works, and they are conferred the protection under literary work category. But despite that, you see, computer programs, as far as the rights on computer programs are concerned, provided or conferred by the copyright law, are little different. So a separate clause under section 14 in relation to this category called computer programs is provided. Though originally computer programs are literary work, you need to understand that they come under the definition of literary work and they are provided the copyright protection under the literary work. But despite that, notwithstanding that they are literary works, the rights which will get conferred on a computer program because of the nature of the work is such. These are computer programs, unlike anything penned down by you on a paper or anything jotted down by you on a paper, any script written by you on a paper or a literary work. Computer programs are a unique kind of works which are falling into the category of literary work, but they require a separate address, or they require a separate attention because of the nature. So that is why under 14, computer programs have been provided with separate rights under a separate clause. Their rights have not been mingled here under 14A. The rights on computer programs are provided under 14B, which reads, in the case of computer program, these are the rights available to the person to do any of the acts specified in clause A, to sell or give on commercial rental or offer for sale or for commercial rental any copy of the computer program, to sell or give on commercial rental or offer for sale or for commercial rental any copy of the computer program. Well, my dear friends, if you look carefully, computer programs have been conferred with the separate kind of rights. Some of the rights in the cases of computer programs are similar to that which are provided under 14A in the cases of literary, dramatical or musical works, but there are some additional rights in the cases of computer programs which are provided by purview of 14B. The additional rights which are provided under 14B in the cases of computer programs are broadly called rental rights. Well, rental right is also an economic right, like the right of reproduction, like the right of issuance of the work to the public, or performance or communication of the work to the public, translation, adaptation of the work, etc. But it is an additional right which lies only with this category or with one more category, not with all other subject matters of the copyright. We have discussed in our previous discussions, my dear friends, literary, artistic, dramatic, musical works, etc. are subject matter of copyrights. Along with that, cinefilms, sound recordings are also the subject matters of the copyright. But as far as literary, artistic, dramatic works are concerned, economic rights in the form of right to reproduce, etc. are available. But in the case of computer program and sound recording, rental right, which is an additional right available only with these two kinds of subject matters or two categories, is provided because of the nature of this work. Computer programs are very easy to imitate or very easy to be reproduced rampantly. In the cases of computer programs as well as in the cases of cinefilms, my dear friends, rental right has been provided, because in both the cases, computer program as well as in the case of cinefilm, the possibility of renting out the work lies, and it is usually rented and it is usually given on rent. We all have grown up seeing the practice in our neighborhood, wherein there used to be shops in our local markets for providing us CDs on rent, video cassettes on rent, video cassette recorders on rent, etc. We all have grown up in that phase where we have seen the transition, where these shops are no more available in the market, but there used to be the culture of renting out of the cinefilms. There used to be culture of renting out of certain works which were copyrighted works. Well, my dear friends, if I comment on that practice, as per the copyright law, that practice was outrightly in violation of the copyright law, because renting out the copyrighted material, if it is a cinefilm, is a prerogative or exclusive right of the owner of the copyright. No other person can rent out that work without the prior authorization from the owner of the copyright. But what those shopkeepers in the neighborhood used to do, they used to just rent out the work of the owners of the copyright without their prior authorization, and we used to pay them the rent for watching those cinefilms, etc. by bringing the copies of video CDs, etc. or video cassettes, etc. on rent from them. So if you look at the language here, in the case of a computer program, same language is used in the case of a cinefilm, where it is written that the right to rent something on a commercial rental or to give something on a commercial rental. If it is a computer program, so giving a computer program on a commercial rental or offering it for sale or for commercial rental or any copy of the computer program. Similarly, renting out, or you can say giving on commercial rental a cinefilm, is the prerogative, is the sole exclusive right of the owner of the copyright. He may authorize somebody to do the same, but nobody else can without the authorization do the same. So we have understood in today's discussion, my dear friends, several rights available to the owner of the copyright as enumerated under section 14, wherein we have seen that with the separate kinds of subject matters, different categories of subject matters, different rights are accruing and different rights are available. Similarly, we have understood that economic rights are also, can be bifurcated in two kinds of rights, which are as follows. Economic rights provided in the form of reproduction, in the form of translation, in the form of making a cinefilm, etc. and rental rights, which are special rights available only in the cases of two kinds of subject matters, that are computer programs and cinefilms. With this, my dear friends, I rest here and I will continue the discussion on the rights under copyright law in my next session. Thank you very much. Have a good day.
Thank you, sir. Thank you so very much for giving us a productive session once again. And dear friends, if you want to give your feedback for this lecture, then do write to us at info.cec@nic.in. Your questions are also welcome here. We will try to give answers to your questions when next time Mr. Ashwani Sewal visits our studio. Till then, take care. Goodbye. We would be meeting again on next Friday. Thank you. Thank you.